What happens when faith, law, and family collide inside a courtroom? This isn't a simple zoning case. It's a battle of beliefs versus the justice system, with bench warrants, default judgments, and allegations of running an unlicensed birthing. Center, 2 defendants stand against the township. The judge now faces the impossible task: uphold the law or face the fury of defiance. This hearing gets intense fast.
All right, this is an unscheduled hearing in the matters of Colon Township versus Alfred E. Yoder and Joanna Ann Yoder. You're Alfred E. Yoder and you're Joanna Ann Yoder. Joanne Yoder, correct? Joann, Joanne Yoder. Also present is Lance Thornton, the Colon Township attorney. As a bit of background, this matter was part and parcel of 2 files. File 25040CZ was a zoning violation case in front of Judge Stutzman in the circuit court. Judge Stutzman had made a ruling in that case and I believe entered a default judgment. I described these matters more carefully on Friday, but I didn't give the same level of preparation here today. Judge Stutzman scheduled a hearing, I believe in July, that the defendants failed to appear for. He did it in order to show cause to find why the defendant should not be found in contempt for failing to appear for the...
The session opens with Judge reminding everyone, this isn't just any case. It's a tangled mess of zoning violations, missed hearings, and civil contempt charges. Alfred and Joanne Yoder failed to appear in earlier proceedings, triggering bench warrants and $1,000 cash bonds. Their absence frustrated the court, leaving the judge questioning whether this couple respects the system, or whether they're simply trying to outmaneuver it.
Hearing, they failed to appear for the order to show cause, and Judge Stutzman entered bench warrants for each case, Alfred Yoder and Joanne Yoder, in file 25040. He set bond in the amount of $1,000 cash. Subsequent to that, another case was filed in file 25533CZ regarding another facility on Marsh Road in very near vicinity of the earlier property that's in 25040. After issuing the bench warrants, Judge Stutzman disqualified himself, and the matter was assigned to me by the Supreme Court and by our Chief Judge, Judge Robert Pattison. Mr. Thornton, on behalf of the township, made a motion to object to that reassignment because I was not a circuit judge. I'm a district judge. And I made a record on Friday indicating that we are a unified court with a joint operating agreement, and each judge is essentially cross-assigned and can back up the other judges. I provided a copy of that agreement to Mr. Thornton. I made a ruling on his motion to recuse me and denied it. I did a formal order for that, which was in the works here today. I think it's been filed and probably on your way. So I denied the motion to recuse myself, and so here I am. So in file 25533, well, let me back up. In the bench warrant cases, I was at the judicial conference the week of August 18th and I took Friday the 22nd of August off as a vacation day. It was my understanding that on or near August 22nd, you presented yourselves at the jail and each posted $1,000 bond. The jail gave you an appearance date of August 29th at 2 o'clock.
But the judge quickly makes his stance clear. This isn't about locking people up. His goal is resolution, not punishment. Yet the Yoder's repeated no-shows create chaos, wasting time and resources. He reminds them that unlike criminal trials, in civil cases a simple no-show means automatic loss. And here, their absence already handed the township a big win, a preliminary injunction against their property activities.
So we were here as an arraignment on your bench warrant for August 29th at 2 o'clock. And there was also a hearing regarding plaintiff's motion for a preliminary injunction in 25533CZ. I learned later, I don't know if both Mr. and Mrs. Yoder were here. I think they were here, or at least Mrs. Yoder was, shortly before 2 o'clock, filed a pleading with the court and then left and did not appear for the hearing, which I was quite disappointed. I spent quite a bit of time trying to prepare for it, and we can't get very far if you're not here. Ma'am, are you recording this?
No. I was communicating.
All right. The matter is being recorded. It's also being live streamed, but you can't make an independent recording of a court proceeding. So anyway, we had the hearing on the motion for the preliminary injunction. And in light of the fact that you weren't there to oppose it, I granted Mr. Thornton's motion for an injunction, at least preliminarily, regarding the construction of the property at 30158 Marsh Road. And
actually, Your Honor, that address is 30246 Marsh Road, where the permanent injunction is granted. The defendants live at 30158.
Okay. And you gave me that same correction there. I had to look in the order. Anyway, the second property. So they got what they asked for. They got the preliminary injunction, not yet a permanent injunction. And I was very unhappy that you weren't here. So I issued a new bench warrant for your failing to appear pursuant to the bench warrant that Judge Stutzman had entered. And I gave 48 hours, which is what we normally do in a criminal case, for you to present yourself either at the jail or at the court. That would have been by 5 o'clock tomorrow. And I learned at about 2 o'clock that you were here at our court. We had some other business to transact. So in the second case, 25533CZ, I issued an order granting the township's request for a preliminary injunction. And we'll talk about that in a minute. So that case is done, at least for the time being. What's at issue here is the bench warrant that Judge Stutzman entered and my subsequent bench warrant. I was provided, again, just a few minutes before I came in, a document called Motion to Quash Bench Warrant. It has a proper heading, it has a case number, and it looks like a proper pleading. There's actually two bench warrants. There's Judge Stutzman's original bench warrant, and then there's my bench warrant, which actually hasn't yet issued. You had until 5 o'clock tomorrow to present yourselves, and you've done that. So I don't need a bench warrant. My goal is not to lock you up. My goal is to try to get this case somehow resolved. You saw what happened with the last two guys that they didn't show up when they were supposed to. They did get locked up. And it's a nuisance because when people get arrested, you got to drop what you're doing and deal with their case. And I shouldn't say it's a nuisance, but it is. We schedule things. We don't just sit around here waiting for something to do. We have a lot to do and we're heavily scheduled. So we made time to deal with that gentleman. As you saw, I gave him time served, and then we had another case. All right, what you missed was your arraignment on the original bench warrant. You haven't yet been found in contempt. Judge Stutzman's bench warrant on its face says it was for civil contempt, not criminal contempt. He checked the box that said civil, for civil contempt. So let me advise you of this. When you are cited for contempt, you have a right to have a hearing where it must be established that there is contempt. In a criminal case, this contempt has to be proven beyond a reasonable doubt. In a civil contempt, it has to be proven beyond a preponderance of evidence. You can't go to jail for civil contempt, at least not initially. However, you can be.
As the judge revisits the record, frustration surfaces. He recalls spending hours preparing for hearings the Yoders never attended. Even when they briefly appeared, they left before proceedings began. For the court, it feels like a deliberate dodge. The judge points out that such actions not only weaken their defense but also risk heavier fines. Civil contempt doesn't send you to jail immediately, but penalties can sting, up to $7,500.
Fined up to $7,500. You have a right to have a hearing where it must be established that there was contempt, which is what I was going to tell you if you'd showed up on Friday. And I would have set some sort of hearing to establish whether or not they could prove you were in contempt. So I'm going to recall my bench warrants. They never actually issued. The bench warrant in 040CZ never issued. So no need to issue those warrants. Arraigned on Judge Stutzman's warrant. What you filed today resembles a proper pleading. Some of the other stuff, I couldn't make head or tail of it. But this is entitled Motion to Quash Bench Warrant Stay Enforcement. You allege improper use of a bench warrant in a civil case, due process violations, and you state in there, no contempt hearing has been held and no order of contempt has been entered. Both of those things are true. We didn't get there yet. Then you argue excessive bail, burden on religious exercise. You asked me to quash Judge Stutzman's bench warrant of July 8th, stay all arrest and enforcement actions pending further review, adjourn further proceedings to permit defendants to file a motion to set aside default judgment. There's default in both cases. If you don't show up in a civil case, you automatically lose and a default judgment enters. Or if a summons and complaint is filed on you and you don't answer it in 21 days, you automatically lose and you're subject to a default judgment, meaning the other side prevails. It doesn't work that way in a criminal case, but in a civil case, it doesn't. So I was very disappointed when you didn't show up. Apparently you'd been here and then left before you actually came in the courtroom. We can't accomplish anything unless you're in the courtroom. So let me ask you first, Mr. Alfred Yoder. I'm assuming, but I don't want to assume anything. So let me ask this. Are you willing to admit civil contempt for failing to appear for Judge Stutzman's hearing? Or do you wish me to set that for a hearing where it must be established that you were in civil contempt?
I filed a special appearance for every court case that was listed.
Yes, but do you wish me to set that matter for a hearing and have them establish that you were in fact in civil contempt?
I'll set it for a hearing.
All right, very good. Joanne Yoder, I'm going to ask you the same question. Judge Stutzman made a finding, or at least an allegation, that you were in contempt for failing to appear. You have a right to have a hearing on that. Do you wish me to set a hearing on your behalf regarding that allegation of civil contempt?
We begin.
So do you have on there why you didn't? Is that correct?
Yeah, it's not Illinois. No, hearing.
All right, do you want me to set a hearing on your behalf? Is that yes?
Yes.
All right. I will do that. Now, default judgments have entered in each case. And
Now comes the choice. Admit contempt or face a hearing to determine it. Alfred and Joanne both request hearings, avoiding direct admission. The judge agrees but warns them. This courtroom isn't optional. If they miss again, jail becomes real. The township's attorney adds pressure, signaling they'll also demand legal costs. Suddenly, what began as zoning violations now threatens to drain the Yoders financially and legally.
in order to set aside a default judgment, a certain standard has to be met. There's a Michigan court rule regarding default judgments and motions to set aside a default. We addressed that a little bit on Friday. Mr. Thorne indicated he was going to file a motion to enter a permanent injunction in the 25533 case. But this issue regarding the bench warrant is just in the 25040 case. I said this on Friday and some of your friends disagreed. I'll say it again. You could benefit from having an attorney, from having legal counsel. We're involving Michigan court rules, involving Michigan statutes, issues of procedure, pleading. And I know you don't necessarily subscribe or wish to participate in our legal system, but it's all I got. And if you are in the system, you could benefit by being represented by somebody that understands the system. I don't think you're going to do it, but I think you could benefit from having a licensed attorney, licensed to practice in the state of Michigan to represent you. But at this point, Mr. Thornton, they've both presented themselves on my earlier order. They're asking for a contempt hearing, which they're entitled to. And so I need to set it for a hearing regarding contempt. Is there anything else you wish to address?
No, Your Honor. I would assume we can address the township's legal costs in the failure to appear at the next hearing.
Yes, that's my thought. Now, I want to make sure that you come. If you don't come, I'm going to leave you in jail like the last guy. until such time as we can have a hearing. I'm not gonna yell at you. I'm not gonna beat you up. I'm not gonna put you in jail. Even if I wanted to, I don't have the authority to put you in jail. But you need to be here to participate in this hearing. They alleged that you were in contempt. They set bonds of $1,000 apiece. You posted $2,000 of cash bond, which the county is holding. So you need to be here so we can address these issues. You don't have to agree with me, but at least you need to come. So I don't have a date right now to give you, but I'm going to set this for a hearing regarding this contempt allegation. The county is going to be, the township is going to be asking for costs for these hearings. As a practical matter, you didn't come for the hearing on Friday, so they automatically won. So that wasn't very complicated, but we didn't get to address this issue. I've inherited this case from Judge Stutzman. I don't have any preconceived ideas about it. What I said Friday, I don't really know too much about it. The first I learned of it, you guys were at a county commission meeting in May with a number of your supporters. And it was a day when a number of public officials were there because we had some reports to enter. So that was the first I even heard about it. I think you both got up and spoke. I know at least Mrs. Yoder, you did, and others spoke on your behalf. This isn't a county commission matter. They don't have the authority to do anything. They can hear your concerns, but it's a judicial matter. It's a court matter. The township has filed this legal action, and they filed it in the circuit court. And they have to address it, whether they agree or disagree. They have to have a hearing, and they have to try to apply the law to the factual circumstance. So I never even had to do that because you didn't show up. I am going to apply the law to your contempt. The allegation is you got notice to appear for a hearing, did not appear. They gave you a subsequent order to show cause, which is an order to appear to show cause why you should not be found in contempt. He didn't show up for the show cause hearing. At this hearing, Mr. Thornton, we may need a witness. And I don't know who that would be. Your zoning administrator?
Could be, I guess. I'm trying to think. The court wants a witness that they failed to appear?
Well, I don't know what, it's a contempt. So you're the complaining party, and you could make representations as counsel. It is civil contempt. But if I set a new date, will you both appear for that? Mr. Alfred Yoder, will you come to court if I set a contempt hearing date? You allege that I didn't give you a hearing and I didn't make a finding, and your allegation is correct. So I'm going to give you a hearing and an opportunity to speak before I make a finding. So if I give you a new date to appear, will you appear?
Yes, sir.
Joanne Yoder, same thing. If I give you a new date to appear, will you appear? All right, then we can address these. The worst thing that's going to happen at this hearing is I'm going to keep your $2,000 and give them to the township. The best thing that would happen, I guess, it would be I found that you were not in contempt and I'd give you the money back. I guess the worst thing that could happen is I could order you to pay $7,500. That's the maximum for civil contempt. But the punishment would only be money damages, not jail. Now, there was some sort of representation last Friday that you are still operating this facility as a birthing facility, which violates the first order from Judge Stutzman. And if that's true, you could be found in criminal contempt and put in jail. So Judge Stutzman ordered that you not continue to operate this as a birthing center. If you are doing that, you could be subject to criminal contempt and put in jail, theoretically, for at least 90 days or until the activity stopped. In the second case, the construction of the new building, you're not to engage in any further construction or activity on that premises until it's further permitted by the township and the state. So I'm not going to.
But the storm doesn't stop there. Rumors surface that the Yoders are still secretly operating a birthing center despite the injunction. If true, this shifts from civil contempt to criminal contempt, and that means possible jail time. The judge doesn't ask directly but issues a stern warning: stop now or face harsher punishment. The courtroom air tightens. The line between faith-driven defiance and law-breaking is razor thin.
I ask you if you're continuing to run this a birthing center, but if you are, you could go to jail for contempt for violation of Judge Stutzman's order. So my advice would be, until we make further rulings in this case, you don't do it. They meant what they said. Don't do it. Do either of you have any questions? Mr. Alfred Yoder, do you have any questions? Ms. Joanne Yoder, do you have any questions? All right, I'm going to set this for another hearing. I've not entered the bench warrants that I directed last Friday, so you're not subject to being arrested. I've got your bond of $1,000 each in the earlier cases, and it goes out 8 hours later, so it kicked me out. All right, so I'm going to find a date that works for Mr. Thornton and works for both of you. And probably, I don't know, maybe on a Friday afternoon, but it's going to be somewhere where we have enough time to do it. This is a matter of public interest. Last Friday, I think a number of your supporters were here. Then there were people here. I couldn't tell whether they were on the township side or your side, but the courtroom was full. And I said that then, and I'll say it now. This is a public courtroom. Anybody that wants to come in here, this gentleman is just a visitor. He's come here from outside of St. Joseph County because he likes to come watch court. He comes several times a year just to make sure I'm doing things right. So it's public. We don't do anything in secret. In addition, this matter is being live streamed and it's available for viewing on YouTube. So your friends and supporters are welcome to come when we have the next date, but I don't yet know when it is. So
I do have a question, Your Honor.
yes.
Obviously the original reason for the Yoder's appearance before Judge Stutzman, when they first failed not to appear, was as part of a show cause for the allegation that they were continuing to run the birthing center in violation of the permanent injunction that had been entered.
All right, we're going to need to set that then. We're going to need to set, that point may have eluded me. So then in which case we're going to need testimony.
Correct.
We need to set hearing on a show cause that they're continuing to operate it as a birthing center, as well as the civil contempt that was found for their failure to appear.
And if we could, Your Honor, pick a date and a time when we had the time to do both of those, that would be my preference from the
Well,
top.
what I'm going to try to do is normally be a Wednesday jury day, and I'll block out perhaps the whole day. In fact, I think I have a day right now. I think September 24th is blank. It is. I don't have a jury trial set that day. I think that's Fair Week. No, it's the week before the fair. And I don't know any reason why we can't do this. So we'll set show cause for continuing to operate the facility and show cause.
Finally, the judge sets a showdown. September 24th. A full-day hearing where everything will come to light: failure to appear, zoning violations, and the alleged illegal birthing center. Both civil and criminal contempt will be on the table. The judge even urges them to get legal counsel, noting how unprepared they seem against the township's attorney. For the Yoders, this date could determine their future.
For contempt for failure to appear. For Wednesday, September 24th. At 2025 at 9 o'clock. We'll block out the entire day. We weren't able to put a criminal case in there. I could have maybe this Thursday stuck something in there, but right now I'll block it out for this. So that work for you, Mr. Thornton?
It does, Your Honor.
All right, we're going to set further hearing in this matter for 9 a.m. Wednesday, September 24th. On the original hearing of violation of Judge Stutzman's injunction that you're continuing to operate in a birthing center. If you're found guilty of that type of contempt, you could be placed in jail. The other contempt, where you fail to appear, is civil contempt, and we'll have a hearing on that matter as well. I'm not being flip or condescending. I really do think you could use some legal advice. We're between the proverbial rock and the hard place. You want to do what you want to do, regardless of what the state says, and the state, through the Colon Township, doesn't want you to do it. So that lands on the judge, who has to make a ruling. So I will see you both here in this courtroom on Wednesday, September 24th at 9 a.m. We'll address the original contempt that you're continuing to run the birthing center, and the secondary contempt where you failed to appear for the hearing. All right, you're free to go. Again, it's my order that you not, Judge Stutzman's order, you not operate this as a birthing center until any further order of the court. All right, you're both free to go. All right, that finishes our day, I hope. Wednesday, the 24th is gonna be a full day. That's gonna be rough, I suspect. All right, well, let's, all right, to stop the live stream, our friend Hale Fredonia is headed back to up north.
As the gavel falls, the judge gives one last warning. The order stands. No operating the birthing center until the court rules otherwise. Supporters may rally, but the law is clear. On September 24th, truth and consequences collide in what promises to be a heated battle. Will the Yoders finally comply, or will defiance push them into jail? The next chapter is set, and stakes couldn't be higher.